Joining us now is Zack Smith, legal fellow at the Heritage Foundation. Zack, welcome back. As we know, the Biden administration plans to ask the Supreme Court to stop the Texas abortion law. What sort of response do you expect from the justices?
Well, thank you so much for having me on. Look, it's kind of ironic that the Biden administration is taking this issue to the Supreme Court. It's going to go to the court on an emergency basis, which means the court will consider it on its so-called shadow docket, which is really just its emergency motions docket, something which unfortunately has received a lot of criticism lately. But you mentioned it before. This is not the first time this issue has come before the Supreme Court. It's not the first time this issue has come before the Fifth Circuit Court of Appeals, which just issued its injunction that would allow Texas's law to remain in place. So I suspect there's going to be a lot more litigation surrounding this bill, but I think for now it's a good sign that this bill can remain in place.
Another question, why has the Texas heartbeat law remained in place so far, and what are the lower courts saying about all this?
Well, the Texas heartbeat bill has several interesting procedural features built into it. Several district courts have tried to stop that law from taking effect. Judge Pittman, a federal district court judge in Texas, wrote a very scathing decision earlier this week prohibiting the law from taking effect. But fortunately, the Fifth Circuit Court of Appeal intervened, basically overruled Judge Pittman, said the law could stay in effect for now while the courts consider the merits of this law, the merits of the legal issues. And so, again, I think that's an encouraging decision. And so far, the Fifth Circuit and the Supreme Court, the last time it heard an emergency appeal based on this same law, but with different parties, basically said for now, the law can and should remain in place while the courts work through these very important legal issues on the merits.
And in your opinion, will the request from the Biden administration to have the Texas law, will it have any effect on any major pro-life issue before the court, such as the case in Mississippi where the justices are set to hear arguments in early December?
Well, this bill is, as I mentioned, coming before the court on an emergency basis, which typically means there's not as much briefing. The justices typically don't take as long to consider the issues. And so I suspect really a lot of these same issues will be dealt with in a much more substantive sense when the court does hear that Dobbs case, which is currently set for argument on December 1st.
And it was exactly 30 years ago that the Senate voted to confirm Clarence Thomas, a Catholic, for the Supreme Court. Now, the Associate Justice, once famous for his quiet demeanor on the bench, has become increasingly outspoken. Can you tell us more about the significance of his tenure?
Yeah, Justice Clarence Thomas's 30 years on the court has been a great thing for our nation. Justice Thomas has been consistent in his commitment to the Constitution, consistent in his commitment to making sure that judges should faithfully interpret the text of the Constitution, the text of the laws as written, and not impose their own value judgments on the American people. He's been a consistent voice on the court for judicial restraint, for faithfully applying the laws and the Constitution as written, and I hope he stays on the court for many more years to come.
Well, we know that you folks over at the Heritage Foundation are staying on top of a variety of other issues. What other issues are you working on?
Sure. Well, one of the big developments today was the Biden Supreme Court Commission released a draft report. They were holding hearings today to consider several proposals, including court packing. Now, the commission said membership was divided on the issue of court packing, which is just adding justices to the court in hopes of getting more politically palatable outcomes or favorable decisions. That's a very bad idea. It's a very dangerous idea. The last time it was seriously considered was the 1930s with FDR, and even then his own party categorically rejected any notion of trying to politicize the courts, and I'm hopeful that cooler heads will prevail and the same thing will happen today.
Well, Zack Smith, legal fellow for Heritage Foundation, thank you so much for your time as always.
Of course, thank you for having me on.